Hello, my name is Malika Basdab. Welcome to PM Express. She is a strong lady with strong conviction and occupies a very, very powerful position. I am talking about Charlotte Osei, Mrs., the chairperson of the elections governing body, the Electoral Commission. But there are those who say she has engaged in actions that they term stated misbehavior and must be removed from office. Is this a political attack on an independent institution, or this is merely adhering to provisions of the Constitution? When we come back from the break, I will introduce a lawyer who will help us dissect all of the issues. Keep watching. You're welcome. You're watching PM Express, and today we are talking about the petition that has been brought to the president, asking that the chairperson of the Electoral Commission, Mrs. Charlotte Osei, be impeached for stated misbehavior. My guest is a lawyer and a friend of the show. I'm talking about Kojoga Adawudu. Sina, welcome.
It's a pleasure.
Good to see you.
Good to see you.
Looking good as always.
Oh.
So, have you read what has been presented, what is being circulated in the media? And I'm talking about the petition.
Yes, I have seen some snippets of those pieces of information that is supposed to be the petition. Okay. And I think that I've looked at it, but to pay fidelity to the law, knowing what it is, I believe I would prefer to discuss the process.
Absolutely, that's the reason we're having this discussion.
What exactly has been put there in the media.
And before we do that, on the face of it, assuming that this was confirmed, what is in the media was confirmed on the face of it, do you think there are issues?
Yes, I've looked at some of the things. I think that job has just been given to the Chief Justice. By the Constitution. She is the one who can determine that whether there is a case to be answered or not. In the legal parlance, we say prima facie. Okay. Prima facie only means that on the face of it, for an objective mind or person, when he looks at it, does it think that this merits some inquiry?
Okay.
And if with her expertise also as a lawyer, if she looks at it and she thinks that it is grounded in law, it's supported, then she can now say that there are some questions to be answered.
Okay, so let's look at the process. We know that the Article 43 of the Constitution establishes the Electoral Commission, and the Electoral Commission here, we are talking about the chairperson or chairman, we are talking about 2 deputies and 4 others, right? Now, that provision also says that the position of the chairperson is akin to the position of a Court of Appeal judge. Therefore, if you want to remove if you want to remove her, you must follow the processes as laid down for removing a Court of Appeal judge. What are those processes? And are they cumbersome?
I don't think it's so much cumbersome, but I believe in the wisdom of the framers of the Constitution. They have set up Article 146. It runs from 1 to 11.
11, yes.
I think 11. That this should be the procedure when some categories of public officials, they have found them for misstated misbehavior or misconduct or the infirmity of the body and the mind, there should be a procedure by which they should. Okay. What is the reasoning why the framers would say that this procedure should be done? Now, the reasoning why they want this to be in camera or this special procedure has been laid down is to protect the integrity, the sanctity, and authority of the office.
Okay, before we even get into that, you are talking about the category of persons as spelled out in 146.
Yes.
Who are these? What are these categories?
The categories, it goes for the superior court judges. When we say the superior court of judicature, we are talking about the High Court, we are talking about the Court of Appeal, and the Supreme Court. Okay. These three courts makes the superior court of judicature. The lower court we have is the circuit court and the district court, okay, which now we refer to as the magistrate court. So these are the lower courts. They are also judicial officers, but there's a different category or procedure by which they would also be dealt with where they are found that there's a stated misbehavior. Now, it says that when you believed, or you did not need to have a personal interest in the matter. Okay. When you believe that there is a stated misbehavior and there is a petition that is made, that petition should be sent to the president. The president takes the petition and refers it to the Chief Justice. That is, if it is not about the Chief Justice herself or himself.
Okay, let me take you back a bit, and forgive me for doing this. You say you do not need to have an interest in the matter. Why is that distinction important? Because we know that in some cases, we know that you can't bring a case in a court to vindicate another person's right. We know that for a fact. We also know that in some cases, unless you demonstrate that you have sufficient interest in a matter, and that if a decision was not taken in the manner that you require, your interest will be affected or jeopardized. Why is that distinction important? That in this case, under Article 146, you don't have to have a personal interest in order to bring a petition.
I would link it with Article 2. Okay. If Article 2 says that if you think that a provision of the Constitution is inconsistent, or any law or any activity that's been done is inconsistent with the provision of the 1992 Constitution, you can come, provided you are a citizen of this nation.
So there's a condition.
Now, if it comes to constitutional matters, because we want to expand the frontiers of the law, you do not need to have an interest in the matter, especially if it is of a public interest nature. So far as the results would be supported by what the Constitution says, you do not need to show that I have an interest. The only criteria there is that you are a citizen of this nation. Okay. So if you can prove that I'm a citizen of the nation, so that it will even ask you when you are filing such a writ, you say that I'm a citizen. It asks you the capacity in which you are approaching the court. All you need to say, I'm a citizen. It is for the court to say, maybe show your birth certificate and others. But so far as you are a citizen,
as proof of citizenship.
Yes, so far as you are a citizen, you can always have access to the court. Okay. Because it's a constitutional matter too, the impediments are not being put in a way as when it is an individual matter like land matter and others, where they will ask you to prove that what interest do you have in that matter.
Because those are private law matters.
Yes, they are private law. And the purpose or the reason is that people don't engage in unnecessary litigation that takes somebody's fight and will always be running to fight for them.
Some busybodies.
Yeah, busybodies. So it is a way by public policy to curb unnecessary litigation. Okay. But when it comes to the Constitution, it's a different ballgame. Okay.
Yeah. So you were talking about now the processes.
The processes. So the petition is sent to the president. Mm-hmm. The president takes the petition, refers it to the Chief Justice. Now, the Chief Justice...
Can I intervene again?
Yeah.
Can the president refuse to forward it? Can the president say, I have seen this petition is vexatious, or it is faulty, and therefore I am not forwarding it?
No.
The president doesn't have any...
Reading that the president has no discretion in that matter. Okay. He has no discretion. The Constitution says that it is submitted to the president, and the president that now
the reason why
the reason why it is, when you read some of the case laws that they have dealt into this provision, it tells you that the moment the petition is sent to the president is the beginning of the judicial process,
okay,
of the impeachment process. So nobody can interfere with that process.
Not even the president.
Not even the president can interfere with that process. So the petition is what kickstarts the process. So the moment the process is given to president, then
his hands are tied. He must necessarily forward it to the Chief Justice.
Now, the Chief Justice has an onerous task to look at it and says that on the face of it, if there's question to answer, then a committee is set up, committee of 5. So you appoint 3 Superior Court judges, and you know the criteria for you to be at the Supreme Court, Court of Appeal and High Court, it should be of moral, high integrity, and these are people that they have some integrity, modicum of integrity, that they will not be swayed or influenced in any way by any consideration. You have 2 other people who will be nominated. They should not be members of Council of State. They should not be parliamentarians.
Why? Why did the Constitution say that they shouldn't be members of Council of State and they shouldn't be MPs either?
You know, what I can hazard, the guess I can hazard is that that committee, they are looking for people of integrity, people with character. Now, you look at Council of State and Parliament, the partisan nature of politics that is infused there. Yes, we are not saying that members of Parliament and Council of State are not men of integrity, are not men of their words. But society is looking for people who would be unbiased, who will not be partial. That committee is found. Because
Article 43 itself actually says that nobody can be appointed Electoral Commission chairperson unless the person qualifies to be MP.
Yeah, it qualifies to be. So that is why it is fused in there, so that from my understanding, you don't have any political coloring and cloud interfering within the work that will be done. So when this committee is set, then they will write to the person, the victim, the person involved, give her the opportunity to be represented by a lawyer, or any aspect of the person's choice. You answer the question, I'm sure you sit as a committee, but it must be in camera.
And in camera means
now,
what?
When we say in camera, it means that it should be to the exclusion of the public. It should just be, because it's a judicial process. So the proceeding, nobody, it can be even in the open court, but there will never be people in the world of the court.
No witness.
Except, now, that is also done not to prejudice the witnesses, the intimidation and recrimination that may come for people who would come and testify.
And media coverage and all of that.
So the wisdom of it is that let it be there. Let's protect the sanctity of the person, the office, so that the independence of it will be. Now, it only goes to say that it suspends the right to information of the public until the end of the whole process.
Proceedings.
Yes, so that at least we can still maintain that independence and authority of the judges, the Superior Court, because it's the people, NCCE, Electoral Commission, SHRAJ, that category of people. Before you are appointed there, it should be a person of high integrity.
Okay. So this 5-member committee, when they go through all of these proceedings, they call witnesses and they do cross-examination, in the end they do a report. What happens to it?
Yeah, the report goes, we say the recommendation. It goes to the president. Now, when it goes to the president is expected to act on the recommendation. If the recommendation says the person should be impeached, the president now will have to issue an order, a letter, to make sure that the person
and the president can't vary it.
The president can't vary it. Here, it is not an advice. It is not an advice.
It's a recommendation.
It's a recommendation of the committee. Don't forget that we have 3 Superior Court judges on that committee who will look at it with their legal eyes. And we have 2 eminent persons who would also be appointed on that committee. Okay. Now, during this process, the president can suspend, by an order, suspend the person to give way. The president can also, whilst the suspension is going on, can revoke the same suspension and ask the person
to return to
post.
Whilst the proceedings are still ongoing.
Yes. So it only goes to tell you that if the committee found that it does not merit the person being impeached, that's why that provision at 10:11 says that the president has that power to revoke that suspension. So these are the process that you have to go through.
So let's pick some of the sticking points. I guess one of the major sticking points is, and I think this played out a great deal in the inquiry into the allegations of corruption and bribery made against some members of the judiciary, the publication of the petition. And it was a matter Justice Paul Utaderi and others brought against Tiger IPI, that the Constitution in Article 146 provides that the proceedings, as you alluded to, as you explained, shall be held in camera. So can the petition be made public? No. If the petition is made public, does that invalidate the entire process?
You see, the interesting thing in that Justice Derry's matter was that there was a case before called Ajay versus Attorney General, when they wanted the late Chief Justice Akwa to be impeached. Now, they published the content of the petition, and the court went on and said that it was unconstitutional because the provision says that there should be confidentiality. Now, if you publish it to others, that means it becomes unconstitutional. You've breached that provision. It is for only the consumption of the president, other than any other person. It's a huge matter. So in the Ajay, that's what the court said. Now, but they stopped there. They did not go that. So what becomes the consequences?
Okay.
When you breach that.
The requirement for non-publication.
Yes. Now, in Justice Derry's case, he was asking now that they have breached that constitutional provision.
Therefore nullify
the whole proceeding. What had happened? The court said, yes, we agree that it's unconstitutional. They breached that provision. However, the mere fact that some provisions have been breached cannot nullify the impeachment proceedings. So they were not going to nullify that. So in there, because he was saying that it should be void and of no effect. And the court said, no, we agree with you that it was unconstitutional. They should not have published the content. However, notwithstanding that, the impeachment process should go on. It should not defeat the object or the essence of it.
Is that a contentious holding? If you admit that this process is not supposed to be opened up, this petition is not supposed to be made public, and somebody makes it public and there are no consequences, is the provision requiring that the petition should not be made public not going to be held in breach or in abeyance because there is no consequence?
No. So what the court said the consequences of it is that when you breach a constitutional provision, it amounts to contempt of the court.
Okay.
It amounts to contempt. It says that in a jurisdiction like India, where there is a legislation that when you breach constitutional provision, it's either in the criminal code or legislation that when you breach constitutional provision, this will be the sanctions.
And
now,
they may be punitive.
It may be punitive. But here we do not have any legislation or anything. But within our laws, the common laws that were used from generations are still part of our law. And the common law, when I say common law, it just means that laws that we as Commonwealth countries, when we were under colonial rule, Britain, that were using Ghana, Nigeria, Sierra Leone, Gambia, those all the laws that applied to us until we also started with our parliament getting our own laws, still forms part of our law, because we learned there are similar things that we learned from. So that's what normally we refer to as the common law. So it is about the Commonwealth countries, all the Commonwealth, the laws that were there, that's what applied. So it says it's a contempt of the court. So that should be the punishment.
But in the case of Anas, Justice Derry and Anas and Tiger IPI, nobody was found.
Yeah, nobody was found. And they also went on that, you see, the moment it is like injunction, when you breach an injunction that don't do this and you do it, it calls for punishment, and the punishment normally is contempt. So the court explained and said that the moment the proceeding starts, it has to be held in camera. There's already an injunction in there. So anybody who violates that
one
must be punished.
Okay.
You understand it? So if you go and publish and you say anything about
regarding what is happening in camera,
it is just like a contempt of the court. Then it also goes on and says in other jurisdictions also, you could be fined for damages and others that you have to pay. Now it took it backtracked into the petition that was done. Nana Akufo-Addo, Jake and versus President Mahama.
Yeah, the election petition.
Now, you saw Article 49, where the presiding officers were to sign the pink sheet.
Yeah.
Most of them did not do it.
And the petitioners were urging upon the court to nullify the results.
That. Now, the court says that, yes, we agree that that provision has been breached. However, it will not nullify what has been done, because the fact that some constitutional provision has been breached does not always means that the process cannot go on.
Interesting.
So that is how the court looked at it and said, yes, they look at the circumstances around which the provision has been breached, and they find out, is it so major or is it significant that the process should move?
Wow.
So that is how the Justice Derry case was.
I think this is an appropriate place to take a break, so that when we come back, we can deal with the key issues involved with this petition that has been brought against the chairperson of the Electoral Commission, Mrs. Charlotte Osei. Is there merit in this? Those who argue that to the extent that the persons who brought the petition have not made themselves known, does that vitiate from the merits of the petition? When we come back from the break, the lawyer will break down the issues. You are watching PM Express. Keep watching. You're welcome back. You're watching PM Express, and we are talking the petition brought against the chairperson of the Electoral Commission, the elections governing body, Mrs. Charlotte Osei. Some people want her out. We don't know who they are because their identities have not been disclosed. There are those who say that itself means that there's no credibility to this petition and it should be thrown out. I'm asking the lawyer, is there merit in that argument that to the extent that we don't know who they are, and the law says that everybody is entitled, everybody has a right to confront their accuser. If you make an allegation against me, I am entitled to know who is making the allegation in order that I can respond to you. But if you make an allegation against me and your identity is not disclosed, my rights have been abused. So some say the petition is dead on arrival.
I don't think so.
Is it as?
I have
Okay.
two options to that. I don't think so. It's a constitutional matter. Now, it says a person, any person who believed. Lawyers act on instructions. So, if the lawyer has petitioned for concerned people, that is why I believe that the lawyer for the chairperson, Thaddeus, is asking for better and further particulars to know.
But he's threatening. He says he wants to know
so
who.
that if, you know, it is a misconduct also. If you are a lawyer, you've not been engaged, and you go on the frolic of your own. Our rule says you can write to him to really state whether he's been engaged or he's not engaged.
And I'm told that Thaddeus is a master of procedure.
Oh, he's well versed with his craft.
Yes.
That's what I can say. And so you definitely have to be engaged. Then you can act for and on behalf of the person. So normally what it's done is that you mention the name that my client or these are the people. But I think in this matter, he chose and said concerned citizens. Now,
and he actually said on radio, and we'll be taking that he thought that it was proper to protect their identities, because even he, the lawyer, he had received so many calls, some of them not very flattering.
Yeah, yes, I'm sure that the process is when the committee is set up, there's a prima facie case established, and it is set up. Definitely, there would have to be a person who will have to be confronted by the chairperson. Okay. There cannot be any faceless person.
So
now that is why, in my belief, was that Tajasori was asking that, give me the names of the people, or I come against you, because some of the things that has been said, if it is not true, are defamatory.
Okay.
Now, if you look at even the Justice Derry's case, it also says that you can sue the person in defamation.
Okay. And I guess then that of Justice Habib Logo as well.
Yeah, you can, yes, Habib Logo. So you can sue the person in defamatory. The mere fact that they have breached the constitutional provision and other confidentiality and all, you could still go for...
And they have put out the petition, which contains scandalous material.
Yes, scandalous material. You can go in for defamation, right? So that is why I'm looking at it that he has gone there and said that, okay, let us know the people without prejudicing your right to initiate the impeachment process. We also have a right to go to court for defamation.
Earlier when you were explaining the processes, you said that the courts holding in Ejechum and even Justice Derry and against the Chief Justice and Tagai IPI, the court's view was that as soon as the petition is submitted to the president, the process has been kick-started, so to speak.
Yes.
In that case, can the EC chairperson's lawyer still bring this kind of letter and ask for better and further particulars? How do you situate that request in knowing that once the petition has been submitted to the president, the processes have started?
Yes, I think that the EC lawyer was reacting to a purported petition.
Okay.
Right. I think he hasn't confirmed that that is the content of the petition.
But now
this is what we are seeing. All we've been told is that a petition has been lodged with the president.
And the presidency has confirmed.
Has confirmed. as to what is the actual content, we might be speculating or conjecturing, because we have seen something on social media. If that becomes the content of the petition that has been sent, in the final analysis it is so, then that is when the issue of it being unconstitutional comes in. Even within the Ajechum case, right, the court came and said that there was no conclusive evidence to show that the petitioner himself published the material. Now, we still don't even have any evidence to show that it was the petitioner
who published this
it, or it came from the presidency.
Is that fatal to the petition and the process?
No, for that one, I can tell you that the court will not depart, but the court would say it's unconstitutional. You breach the confidentiality of the process. It has been breached. If they find out, or there's conclusive evidence that it was the petitioner and others, or the consent electoral commission workers
who leaked their own petition.
Yes.
But you are saying that even if that were to be the case, the holding will be that it will not invalidate.
Yes, going by the
dairy, which is later than a J2.
Yes, going by that, it would go ahead and say it does not stop the impeachment process.
I am curious about the position of Thaddeus Sory's letter and what the effect is. Because we know that now the petition, and you said something in just which I took, a suggestion that the petition may have actually been forwarded from the presidency to the Chief Justice. If that were to happen, what is the effect of Thaddeus Sory's letter? Does it have any effect
if you look at if you look at Thaddeus Sory's letter, my mind makes me believe that they are gearing towards an action in defamation. Not really about the
substance of the petition.
No, the substance of the petition. Because they believe that there have been some scandalous and defamatory things that had been in what has been seen, and actually being signed by
the lawyer.
Yeah, Maxwell Opoku. He was my lecturer.
Oh, okay.
Yes, you know. So if you look at the intent and look at the letter, how it's been cowed, it tells you that they may kickstart process in damages. That's why even part of the letter says that without prejudicing or saying your right to the process to go in, we have a right in defamation. So give us the names. If not, we will take you as a defendant. So it tells you that they are not perturbed by the process. If the Chief Justice determines that there is a matter, or the committee has to inquire into the matter, they will definitely submit to it. But they have also their right in defamation to show that some of the things that have been said are embarrassing, they are scandalous, and frivolous. And
the lower has standing in the eyes of right thinking.
Yes.
As is often said in mundane circles. Let's pick a bit of sound of what the lawyer for the petitioners said when he spoke to us on the phone. And I'm talking about Maxwell Opoku. He's the one who is championing, or he is leading, he's representing these so-called aggrieved workers of the Electoral Commission.
I am a consummate professional. Therefore, when the petition was submitted to the office of the president, that was the office of the president. And therefore, I do not do things in media litigation. Therefore, I did not know how it got into the media landscape or the comments to be made. So I told you that I am constrained in commenting until I have confirmed that maybe that is the petition we submitted, which has found its way into the media. You media said you have unimpeachable sources. Some of you said you have intercepted and I told them that I do not deal with intercepted evidence or documents. But now that is confirmed, that what we submitted to the president office has acknowledged, I'm able to talk. That's why when you called me this time, I said I'll talk. So that's how it is. I have listened to what you read to me. My only response is that I believe those who issued that letter, I'm not sure if they have been petitioned or if they have been copied with a petition by me or by the office of the president.
Yeah, welcome back. You just heard a lawyer for the petitioners, Mr. Maxwell Opoku Agyeman. Let me talk to Kujoga. Did you hear him raise a critical question that Thaddeus Osei's letter to him, he is unaware that Thaddeus Osei and his client were copied in the petition?
It just goes back to the 146, the confidentiality.
Mm-hmm.
You don't copy it to anybody.
So,
it is only for the president. So he's making a point that I have not copied them this letter.
So what are they?
So that's why I'm saying that what they will have responded to will have been what they have seen in the media, which is purported to have been the petition. Right? And they, if I guess right, their right to sue in defamation is what they might be looking at immediately.
Should they have waited for the process? Because from what he just said, you haven't been copied in a letter, and you are responding to a letter which is in the media, which may be in doubt. It may or may not be in doubt, and you are responding to the letter. If he's responding to them, what is he going to tell them?
No, I think that it gets to a point when you see some of these things and you feel that they are defamatory, they are unkind words, they lower your standard, and people form different opinion about you in society. You find out from the person who has written that document, the purported document, whether what has been done there, it's true and it emanates from that person. I believe in a bit of finding out and doing that, that is why that was written to the lawyer. You see, the interesting thing is that Maxwell Opoku Agyeman, he trained as a journalist before he became a lawyer.
Before he became a lawyer?
Yeah.
Okay.
So he has a journalistic background. And I'm told, my source of information, I believe that he and Charlotte, they are even mates.
Yeah, 94. Yeah, because I have read some.
But that's the beauty of this, our profession. You sit in class, you do things together, you lock your horns, you slag it over. At the end of the day, it is about work we are doing, our profession. There's no enmity.
No ill will towards...
No ill will towards each other. If you understand it as a professional that we are doing our work.
But what we are reading on social media are suggestions that there is ill will dating back to the days in school. Because we have read posts by a certain Jody who is accusing Maxwell Opoku Agyeman of treachery, and that what he's doing is vendetta.
You can't take those things away in life. Let's even take the legal professional. In life, the vicissitudes of life, you find some of these things. You know, everywhere you find people have issues with you. You may have issues when somebody thinks that, oh, we have sorted it out, but it plays back. I think let's give him the benefits.
But I was curious, this other lawyer who is publicly accusing him of treachery and vendetta and he will lose and is a disgrace, does the law profession accept that? I thought that the rules and regulations that guide the conduct of lawyers, even at the bar, lawyers are not supposed to publicly criticize each other's work.
No. I think the standard at the bar, which we have met, is yes, you can engage your colleague, but there are some utterances or some words that you cannot use for your colleague.
If your colleague is handling a case and you accuse him of treachery and vendetta and prophesying that he will lose and he cannot win in this case, and is that permissible?
You know, we are human beings. Every profession has its own ethics and code. The mere fact that somebody might exceed the limit does not mean that within the profession, when it happens like that, the seniors or others see it and say, no, this cannot be tolerated at the bar. It is not done. It's unacceptable. We chastise each other. I see maybe some of my seniors or even juniors, and I tell you, no, this is not done at the bar. So if they had their own different, and maybe they have their own personal scores and they think that it is time to settle personal scores, that is it. But I think that let's keep the standards at the bar. We may have issues with others. I have issues with some of my classmates.
But you can't go and put it public.
We don't. I don't see them, and I think I will do that.
Okay. We have to take a break. When we come back, we will talk about the politics.
Definitely.
Because a lot of talking is going on, and in fact, a lot of threats are going on. We have heard the minority leader state categorically that the minority will resist any attempt by the president to encroach upon an independent institution such as the Electoral Commission. Does he have any basis for this claim? When we come back from the break, we will continue with this discussion. You're watching PM Express. Keep watching. You're welcome back. You're watching PM Express. And we are talking the petition against the Electoral Commission chairperson, Mrs. Charlotte Osei. And we are going to talk about the politics of it because Minority Leader Haruna Idrisu says the president is encroaching upon an independent institution and this will be resisted. Is there any evidence to Maybe my lawyer has some evidence. The details you have given us about the processes, you have not questioned the process so far at any point. So when you hear the minority leader, whom I guess is your friend, say that the president is encroaching upon an independent institution and he's cataloging removal of public office holders in other departments and agencies, and he's using that as a basis for this claim. Does he have a point?
Let me say this, and I would say it not in the literal sense, so that people don't take me on. No, Haruna is my senior, and we learned few things from him, and we share notes. The minority leader has big ears. What I mean by big ears, that he hears a lot of information, a lot of things are communicated to him. I'm also not naive to also say the politicians can do anything except to change a man to a woman. And if you look at the process, it is only for the Chief Justice to determine that there's a prima facie case or not. So, if the political authorities and the judiciary, which they will have to work hand in hand, although there's separation of powers, they're independent-minded, anything could happen. However, I don't think that looking at the integrity of the people who would have to sit on such committee, there is a kind of safety net that will sieve the kind of influences and any consideration. You know, they are human beings who will sit there. That is why it is being made to be in camera, or that it should not even be published, so that, you know, they'll be carried away by the sentiments of society as to what the petition is about, that they will be able to influence or be compromised. So you don't even hear anything, and you are dealing with the matter with your independent. So if the minority leader comes and says that he has some information and others that this is being orchestrated to make sure that she's taken away, and based on, you know, the hula baloo that surrounded her
senseless
appointment,
politicization of an otherwise normal process, because this is the same process through which the Chiraj boss, Mrs. Vivian Loretta Lamptey was taken through. There was no question about anybody witch hunting her or anybody using any influences to get her out. It was the rules. She had her day. She made her defenses. And in the end, the committee came to a conclusion that she had to be removed. And the president just followed that.
Yeah.
Why is this one being viewed with political lens?
I think the difference in this matter is that if you look at her appointment, the hula baloo that surrounded her appointment, that the New Patriotic Party, which is in government now, which as at that time was in opposition, felt that she was too young to take that position.
Really?
Oh, yes. I think when you look at their...
I don't remember the party as an institution opposing her appointment. Yeah. I know that a journalist went to court, and I'm talking about Richard Sky, and in spite of that, she was appointed.
Yes, they were appointed. Yet, so looking at some of these things, may form the opinion why the minority there. But as I said, he is the leader of the minority group, and he may have a lot of information.
And that is the reason why there is a bigger burden on him as a lawyer, as a minority leader, to not say publicly that a constitutional process will be resisted.
No. I don't think that anybody can resist that.
But that's what he said.
Yes, it's a process that the fidelity to that process must be respected by all. And the thing that will happen is that if it is found out that there is an orchestration by people who says they are the concerned,
there are safety nets to deal with that.
But there's safety net within even the committee to sieve some of this consideration and others that would be factored into the process.
Mr. Dawudu, it's been an honor.
It's a pleasure.
Thank you. Thank you.
Kojoga
Dawudu is a private legal practitioner. He's brought us exciting education. I have been educated. I believe you have been educated too. Thanks for watching PM Express. God willing, tomorrow we will bring you another exciting discussion on PM Express. Until then, my name is Malik Abbas Dabu. Bye-bye. Great.